On December 4th of 1797, the state of North Carolina joined 11 other states by voting to ratify the 11th Amendment to the United States Constitution, which reads in full, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state." The provision was proposed and enacted in order to overturn the United States Supreme Court's first major decision in Chisholm v. Georgia, 1793, in which the court, under Chief Justice John Jay, ruled by a vote of 4-1 in favor of Alexander Chisholm, the executor of the estate of South Carolinian merchant Robert Farquhar, who attempted to sue the state of Georgia, seeking £100,000 sterling for supplies that Farquhar had provided to the state for the provisioning of Continental Army troops stationed in the city of Savannah, but never been paid for. The Supreme Court under Chief Justice Oliver Ellsworth further affirmed in Hollingsworth v. Virginia, 1798, that all active cases then under consideration which had been brought against states by citizens of other states under the ruling made in the Chisholm case were to be dismissed, including those filed prior to the ratification of the 11th Amendment. The court's ruling in Hollingsworth also separately affirmed that the President of the United States has nothing to do with the proposition or adoption of amendments to the Constitution. On June 15th of 1804, the state of New Hampshire joined 12 other states by voting to ratify the 12th Amendment to the United States Constitution, which reads in full, "The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president and all persons voted for as vice president, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest number not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed. And if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. 156 years ago today, the state of Georgia voted to ratify the 13th Amendment to the United States Constitution, 2 days after the state of North Carolina had ratified the amendment and 4 days after the state of Alabama. The Peach State joined 26 other states to enact a measure which reads in full, "Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Congress shall have power to enforce this article by appropriate legislation." The 13th Amendment was the first of 3 Reconstruction Amendments ratified in the aftermath of the war between the states, and contrary to our national mythology, it did not abolish either slavery nor involuntary servitude in the United States. Rather, it codified slavery and involuntary servitude as perfectly legal forms of punishment for crime, and it thereby incentivized the criminalization of poverty and otherwise minor offenses in order to provide a steady stream of warm bodies into a prison industrial complex that profits from convict leasing and forced labor, and is dissected in much greater detail in Ava DuVernay's Academy Award-nominated Netflix documentary 13th. On July 9th of 1868, the state of South Carolina joined 27 other states by voting to ratify the 14th Amendment to the United States Constitution, though the process was fraught with peculiarities. The states of New Jersey and Oregon ratified the provision in September of 1866, after which subsequent state legislatures attempted to rescind those ratifications in February and October of 1868, respectively. Similarly, the state of Ohio ratified the amendment in January of 1867, after which a subsequent legislature attempted to rescind that ratification in January of 1868. At the time, the 39th Congress rejected New Jersey's attempt to rescind its ratification, and after the states of Alabama and Georgia ratified the provision in July of 1868, Secretary of State William Henry Seward proclaimed its adoption. All three states eventually re-ratified the amendment, Oregon in April of 1973, Ohio in March of 2003, and New Jersey in April of 2003. The states of North Carolina, Louisiana, and South Carolina, meanwhile, had initially rejected the amendment between December of 1866 and February of 1867, before all reversing course and ratifying it in July of 1868, largely because the Reconstruction Acts, which were vetoed by Democratic President Andrew Johnson before being enacted by a congressional override in March of 1867, established martial law throughout the American South in the aftermath of the war between the states and required the ratification of the 14th Amendment in order for formerly Confederate states to gain readmission into the Union. The first section of which reads in full, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The first fundamental provision included in this section is the Citizenship Clause, which established the legal concept of birthright citizenship. This clause specifically codified the premise, introduced in the Civil Rights Act of 1866, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. The Supreme Court further ruled in Elk v. Wilkins, 1884, that the main object of the opening sentence of the 14th Amendment was to settle the question that all persons born or naturalized in the United States and owing no allegiance to any alien power should be citizens of the United States and of the state in which they reside. Despite the unambiguous clarity of its language, an executive order was issued on January 20th of 2025, falsely asserting that the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States, and that it has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. In addition to being factually and historically untrue, Executive Order 14160 is itself inherently unconstitutional. It claims that its provisions have been ordered by the authority vested in its signer as the President by the Constitution, despite the fact that the Constitution does not vest that authority in the President. The primary intention of Executive Order 14160 is to interpret the 14th Amendment, and the interpretation of law, up to and including the United States Constitution itself, is an authority vested solely in the judicial branch, the Supreme Court, and the courts that operate under it, that cannot be legally exercised by any order issued by the executive branch. The second fundamental provision included in this section is the Due Process Clause, which reiterates and reinforces the nearly identical stipulation included in the Fifth Amendment, which states in part that no person shall be deprived of life, liberty, or property without due process of law, that being the requirement that governmental bodies, be they federal, state, or local, must adhere to the restrictions placed upon them by the foundational documents that form them without violating the rights of the people under whose consent they operate, in order for the judgments of those bodies to be considered and treated as legitimate. It is a legal concept established in print in Clause 39 of the Magna Carta, which was sealed by King John of England in June of 1215, and stated in part that no free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. The United States Supreme Court has consistently held that due process of law provides four legal protections: procedural due process in civil and criminal proceedings, substantive due process, safeguarding individuals from majoritarian policies, a prohibition against the creation of laws that are too vague for the average citizen to understand what they require or restrict, and the incorporation of the Bill of Rights, applying the first 10 amendments to the United States Constitution, not just to the federal government, but to the individual states of the Union as well. The third fundamental provision included in this section is the Equal Protection Clause, which applies not just to citizens of the United States, as the preceding Privileges or Immunities Clause did, but to any person within its jurisdiction, regardless of their legal status or the conditions of their arrival. Given this verbiage, the Supreme Court ruled in Wong Wing v. United States 1896 that it must be concluded that all persons within the territory of the United States are entitled to the protection guaranteed by the Fifth and Sixth Amendments, and that even aliens shall not be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, nor be deprived of life, liberty, or property without due process of law. One of the most notorious and controversial equal protection rulings in American history occurred in December of 2000 when the Supreme Court ruled in Bush v. Gore that the manual recounting of ballots cast in that year's presidential election in Florida be halted, resulting in then-incumbent President George Walker Bush receiving that state's 25 electoral votes for a total of 271 against the 266 collected by former Vice President Al Gore, who thereby lost that election despite receiving almost 544,000 more votes than his opponent, and marking just the fourth time at that time in American history that a candidate had become the president despite losing the popular vote. Section 2 of which reads in full, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. This section primarily supersedes the third paragraph of Section 2 of Article 1 of the Constitution, which had previously established that representatives were to be apportioned among the states by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons, those vaguely described other persons, of course, being slaves. The language of this section also indicates that the apportionment of representatives is based on the number of persons in each state, without regard for their legal status or the conditions of their arrival, and not merely the number of citizens. Section 3 of which reads in full, no person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. This section further codifies provisions established 6 years earlier in the Second Confiscation Act, which indicates that if any person shall incite, set on foot, assist, or engage in any rebellion or insurrection against the authority of the United States, or the laws thereof, or shall give aid or comfort thereto, or shall engage in or give aid and comfort to any such existing rebellion or insurrection, that person shall be forever incapable and disqualified to hold any office under the United States. The provision was intended to prevent those who had allied with the Confederacy during the war between the states from infiltrating the federal government, but by 1898, Congress had voted to remove such disability for everyone then living and disqualified by their allegiance to the Confederacy. More recently, the Colorado State Supreme Court ruled that then former President Donald Trump was no longer eligible to run for office due to his engagement in the attempted insurrection committed at the United States Capitol building on January 6th of 2021. Trump was successfully impeached 1 week after the attack on a single charge of incitement to insurrection by a House vote of 232 to 197, though the Senate subsequently failed to convict him with 57 guilty votes and 43 not guilty votes, falling short of the 2/3 majority required for conviction by Section 3 of Article 1 of the Constitution. In Trump v. Anderson 2024, the United States Supreme Court, which then included 3 associate justices appointed by Trump himself, ruled that the authority to enforce Section 3 of the 14th Amendment belongs exclusively to the United States Congress, and that individual states may therefore not declare candidates ineligible under it. Sections 4 and 5 of which read in full, the validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for service in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. The Congress shall have power to enforce by appropriate legislation the provisions of this article. This section affirmed the public debt taken on in the Union's efforts to suppress the Confederate insurrection during the war between the states, and explicitly voided any debt associated with the waging of that insurrection and with the emancipation of the slaves that insurrection was intended to keep enslaved, and expressly prohibited the collection of any such debt. In 2011, Congress, under the control of the Republican Party, attempted to refuse to raise the United States debt ceiling, that being the maximum amount of money that the federal government may borrow, during the presidency of Barack Obama, prompting President Bill Clinton to make the argument that Section 4 of the 14th Amendment not only permits but requires the executive branch to ignore the debt ceiling in the fulfillment of any debts authorized by Congress in its appropriations bills. On February 3rd of 1870, the state of Iowa joined 27 other states by voting to ratify the 15th Amendment to the United States Constitution, which reads in full, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have power to enforce this article by appropriate legislation." The state of New York attempted to rescind its ratification almost a month prior to the amendment's certification by Secretary of State Hamilton Fish, and only ratified it again in March of 1970, and the amendment led to the passage of the Enforcement Acts of 1870 and 1871, the third of which specifically classified many of the intimidation tactics used by the Ku Klux Klan as federal offenses. 6 years after its ratification, the Supreme Court ruled in United States v. Reese that measures used by certain states for the purpose of restricting the ability to vote, such as poll taxes and literacy tests, did not violate the 15th Amendment, despite the fact that such measures made it disproportionately more difficult for non-Caucasian citizens to vote. That same year, Republican Governor Rutherford B. Hayes emerged victorious from the quagmire of a highly contested presidential campaign marked by substantial cases of election fraud and voter intimidation committed by white supremacist paramilitary groups such as the White League and the Red Shirts. Hayes had collected one more electoral vote than his opponent, despite losing the popular vote by more than 250,000 votes, marking just the second time in American history that such a thing had happened, in part due to support he received from several Southern Democratic states in exchange for his assurance that he would allow them to operate without federal interference. Upon winning, Hayes withdrew federal troops from those states and refused to enforce federal civil rights protections, and based on the ruling in Reese, measures like poll taxes and literacy tests became key components in what were known as Jim Crow laws, which were implemented for the purposes of maintaining and enforcing racial segregation throughout the American South. The 16th Amendment, which reads in full, "The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration," was ratified. As Professor Sheldon D. Pollock wrote on February 25, 1913, in the closing days of the Taft administration, Secretary of State Philander C. Knox, a former Republican senator from Pennsylvania and Attorney General under McKinley and Roosevelt, certified that the amendment had been properly ratified by the requisite number of state legislatures. 3 more states ratified the amendment soon after, and eventually the total reached 42. The remaining 6 states either rejected the amendment or took no action at all. Notwithstanding the many frivolous claims repeatedly advanced by so-called tax protesters, the 16th Amendment to the Constitution was duly ratified as of February 3, 1913. With that, the Pollock decision, that being the Supreme Court's 1895 ruling in Pollock v. Farmers Loan and Trust Company, was overturned, restoring the status quo ante, or the previously existing state of affairs. On April 8th of 1913, the state of Connecticut joined 35 other states by voting to ratify the 17th Amendment to the United States Constitution, which reads in full, "The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. The executive authority of a state is its governor, and writs of election are orders issued by a governor to schedule special elections. There are currently 2 such elections scheduled to be held on November 3rd of 2026, on the day of the federal midterm elections that will decide the composition of the 120th United States Congress. The seat vacated by James David Vance when he resigned to take up the office of the vice president is currently held by John Allen Husted, who was appointed by Ohio Governor Mike DeWine, under whom he served as lieutenant governor. And the seat vacated by Marco Rubio when he he resigned to take up the office of the Secretary of State, is currently held by former Attorney General Ashley Brooke Moody, who was appointed to the seat by Florida Governor Ron DeSantis. On January 16th of 1919, the states of North Carolina, Nebraska, Missouri, Wyoming, and Utah joined 33 other states by voting to ratify the 18th Amendment to the United States Constitution, which reads in full, "After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof, for beverage purposes, is hereby prohibited. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress." The enactment of the measure was the result of the temperance movement in the United States, which sought to restrict the consumption of alcohol and marked the first time that a constitutional amendment included a ratification deadline, in this case 7 years from the date that Congress submitted the proposal to the states, a practice upheld by the Supreme Court 2 years later in Dillon v. Gloss. The Supreme Court additionally ruled in Coleman v. Miller, 1939, that if Congress does not include a ratification deadline in an amendment, then the proposal remains pending before the states indefinitely and can be ratified at any time. Of the 48 states in the Union at the time, only Connecticut and Rhode Island rejected the 18th Amendment, and 9 months after the measure was ratified, Congress passed the National Prohibition Act, otherwise known as the Volstead Act, named after Chairman of the House Committee on the Judiciary Andrew Volstead. That act was vetoed by President Woodrow Wilson, whose veto was overridden by the House of Representatives and the Senate, after which the Volstead Act established that no person manufacture, sell, barter, transport, import, export, deliver, furnish, or possess any intoxicating liquor with more than 0.5% alcohol by volume. Far from reducing the consumption of alcohol, prohibition provided the ideal circumstances for organized crime to flourish, including the brutal year-long Castellamarese War between Cosa Nostra bosses Giuseppe Mazzari and Salvatore Maranzano, and murder rates rose nationwide by 42.5%. 13 years later, the Volstead Act and the 18th Amendment were both repealed when Congress passed the Blaine Act, named after Wisconsin Senator John J. Blaine, and the 21st Amendment was ratified in December of 1933. On August 18th of 1920, the state of Tennessee voted to ratify the 19th Amendment to the United States Constitution, less than 3 months prior to the presidential election of that year, in which then-Republican Senator Warren G. Harding defeated Democratic Governor James Middleton Cox by more than 7 million votes. The volunteer state joined 35 other states to implement a measure which reads in full, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation." Within 2 years, the Supreme Court unanimously upheld the amendment, answering a challenge by the state of Maryland, which had rejected the amendment in February of 1920 and did not ratify it until March of 1941, by ruling in Lesser v. Garnett that stipulations within the Maryland state constitution that limited the right to vote only to men, specifically men 21 years and older who owned at least 50 acres of land or property valued at 30 pounds or more, were superseded by the United States Constitution and any amendments made to it by the Supremacy Clause included in Article 6 of the Constitution, which indicates, "This Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land, anything in the Constitution or laws of any state to the contrary notwithstanding." Women won the right to vote, and shortly after, Cox lost. On January 23rd of 1933, the state of Missouri joined 35 other states by voting to ratify the 20th Amendment to the United States Constitution, Section 1 of which reads in full, "The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified." This section supersedes the 12th section of an act relative to the election of a President and Vice President of the United States, in which Congress established in March of 1792 that the term of 4 years for which a President and Vice President shall be elected shall in all cases commence on the 4th day of March, next succeeding the day on which the votes of the electors shall be given. The measure shortened the so-called lame duck period, during which an outgoing president still holds the office while awaiting the inauguration of their successor and the transfer of power, a span of time that was long enough that in 1916 Woodrow Wilson prepared a contingency in the event that he lost re-election to Republican Charles Evans Hughes in the midst of World War I. In that circumstance, Wilson intended to dismiss his Secretary of State, Robert Lansing, who was at that time second in the line of succession under the Presidential Succession Act of 1886, and appoint President-elect Hughes to replace him, after which Wilson and his Vice President Thomas Riley Marshall would have resigned, elevating Hughes to the presidency immediately. A similar strategy was facetiously proposed in 2024 when then-current Vice President Kamala Harris lost election to former President Donald Trump, with some Democrats suggesting that then-President Joe Biden resign in early November of 2024 due to health concerns, thereby making Harris the 47th President of the United States for the 11 weeks prior to the inauguration. Section 2 of which reads in full, "The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day." This section supersedes the 4th section of Article 1 of the United States Constitution, which had previously established that the Congress shall assemble at least once in every year on the first Monday in December. This measure shortened the so-called lame duck period, during which the departing members of Congress still hold their office while awaiting the inauguration of their successors and the transfer of power, and ensured that in the event that the Electoral College fails to select a president under the stipulations of the 12th Amendment, which indicates that if no candidate receives the votes of a majority of the whole number of electors appointed, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president, with the vote being taken by states, the representation for each state having 1 vote. This contingent election will be conducted by the incoming representatives rather than the departing representatives. Section 3 of which reads in full, "If at the time fixed for the beginning of the term of the president-elect shall have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. And the Congress may by law provide for the case wherein neither a president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified." This section led to the inclusion of failure to qualify as a potential option in the Presidential Succession Act of 1947 in order to account for events like the constitutional crisis that nearly occurred during the presidential election of 1800, in which Vice President Thomas Jefferson and New York Senator Aaron Burr each received 73 electoral votes, resulting in a series of contingent elections. The House of Representatives remained deadlocked through 35 rounds of voting until former Secretary of the Treasury Alexander Hamilton persuaded several Federalists to shift their support, resulting in Jefferson's victory by a vote of 10-4 on the 36th ballot. Sections 4, 5, and 6 of which read in full, "The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a president whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a vice president whenever the right of choice shall have devolved upon them." Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Just 23 days after the ratification of the amendment, an assassination attempt was made against President-elect Franklin Delano Roosevelt, who had defeated Republican incumbent Herbert Hoover 99 days prior, by Royal Italian Army soldier Giuseppe Zangara during a speech in Miami, where Chicago Mayor Anton Joseph Cermak was inadvertently shot instead. Had Zangara's attempt been successful under the provisions of the 20th Amendment, Roosevelt's vice president-elect, John Nance Garner III, would have been inaugurated as the 32nd president on March 4th of 1933, 2 days before Mayor Cermak died of his wounds. 88 years ago today, the states of Ohio, Pennsylvania, and Utah voted to ratify the 21st Amendment to the United States Constitution. The Buckeye State, the Keystone State, and the Beehive State joined 33 other states to enact a measure which reads in full, "The 18th Article of Amendment to the Constitution of the United States is hereby repealed. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress." The amendment was the second ratified in 1933, remains the only amendment to repeal a previous amendment, and is the only amendment ratified through the secondary process of state conventions provided in Article 5 of the United States Constitution, which requires 3/4 of the states of the Union rather than 2/3 of both chambers of Congress. On February 27th of 1951, the state of Minnesota joined 35 other states by voting to ratify the 22nd Amendment to the United States Constitution, which reads in full, "No person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of the president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress." Proposed by Republican Representative Earl Corey Mishner in February of 1947 in response to the 4 consecutive presidential elections won by Franklin Delano Roosevelt, the measure was ultimately ratified by 41 states in total, while both Oklahoma and Massachusetts rejected it, and the remaining 5 states took no action. The maximum length of time that a single person could serve as president then is 9 years, 364 days. In the case of a vice president who were to ascend to the presidency 2 years and 1 day into their term before later being reelected twice. Other than Franklin Roosevelt, however, no person has served as president for more than 2,922 days, or 8 years exactly. On March 29th of 1961, the state of Ohio joined 37 other states by voting to ratify the 23rd Amendment to the United States Constitution, which reads in full, "The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. The Congress shall have power to enforce this article by appropriate legislation." Proposed by Tennessee Representative Estes Kefauver, the measure was ultimately ratified by 40 states in total, while Arkansas rejected the amendment and the 9 remaining states took no action. An attempt to repeal the amendment was made in August of 1978 when California Representative Don Edwards proposed the District of Columbia Voting Rights Amendment, which was ratified by only 16 states, the most recent being Delaware in June of 1984, but which laid the groundwork for the District of Columbia statehood movement. In November of 2016, 85.7% of district residents voted to petition Congress for statehood, proposing to name the state the Washington-Douglas Commonwealth, and in January of 2019, D.C. Representative Eleanor Holmes Norton introduced the Washington, D.C. Admission Act, a bill that was approved by a vote of 232 to 180 before reaching the Senate, where Republicans refused to consider it as Donald Trump threatened to veto it. Representative Norton has continued to reintroduce the bill at the beginning of every Congress since, most recently with the support of Maryland Senator Chris Van Hollen Jr. On January 23rd of 1964, the state of South Dakota joined 37 other states by voting to ratify the 24th Amendment to the United States Constitution, which reads in full, "The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. The Congress shall have power to enforce this article by appropriate legislation." The measure was ultimately ratified by a total of 42 states, while Mississippi rejected the amendment and the 7 remaining states took no action. After the ratification of the 15th Amendment in February of 1870, which established that the right of citizens of the United States to vote shall not be denied on account of race, color, or previous condition of servitude, measures like poll taxes and literacy tests were implemented throughout the former Confederate states as key components in what were known as Jim Crow laws, which were designed to maintain and enforce racial segregation throughout the American South. At the time of ratification, the states of Alabama, Arkansas, Virginia, Texas, and Mississippi used poll taxes as a means of restricting the ability to vote, and only Arkansas voluntarily rescinded its poll tax. The Supreme Court ruled in Harmon v. Forsynius 1965 that policies designed to replace poll taxes with different practices meant to serve the same purpose are also unconstitutional, since under the 15th Amendment, the poll tax is abolished absolutely as a prerequisite to voting, and no equivalent or milder substitute may be imposed. A decision that establishes that state laws requiring voter identification are also unconstitutional. The remaining 4 states were forced to rescind their poll taxes when the Supreme Court ruled in Harper v. Virginia Board of Elections 1966 that such measures are unconstitutional for state and local elections as well as federal. On February 10th of 1967, the state of Nevada joined 37 other states by voting to ratify the 25th Amendment to the United States Constitution, Section 1 of which reads in full, "In case of the removal of the president from office or of his death or resignation, the vice president shall become president." This section supersedes the provision included in Section 1 of Article 2 of the Constitution, which indicated that a vice president merely exercised the powers and duties of the office of the president in cases of removal, death, resignation, or inability. In the first instance of that provision's implementation, Vice President John Tyler rejected the intention of the original clause when William Henry Harrison became the first president to die in office just 1 month into his term, having contracted pneumonia after delivering a 2-hour-long inaugural address on March 4th of 1841. Tyler had himself sworn in as president, and though his opponents referred to him as His Excellency, Congress eventually voted to recognize him as the legitimate president of the United States, thereby establishing the Tyler precedent that was ultimately codified in this first section of the 25th Amendment. 7 vice presidents, including Tyler, succeeded the presidents under whom they served in this way prior to the amendment's ratification. Millard Fillmore after Zachary Tyler died of gastroenteritis in July of 1850. Andrew Johnson after Abraham Lincoln was assassinated in April of 1865. Chester A. Arthur after James Garfield was assassinated in September of 1881. Theodore Roosevelt after William McKinley was assassinated in September of 1901. Calvin Coolidge after Warren G. Harding died of a myocardial infarction in August of 1923. And Lyndon Johnson after John F. Kennedy was assassinated in November of 1963. Section 2 of which reads in full, "Whenever there is a vacancy in the office of the vice president, the president shall nominate a vice president who shall take office upon confirmation by a majority vote of both houses of Congress." The first implementation of this provision occurred in October of 1973, when then Vice President Spiro Agnew resigned, after which President Richard Nixon nominated Michigan Representative Gerald Ford to replace him. Ford was confirmed by the Senate and the House and sworn in on December 6th, and less than a year later, Richard Nixon himself resigned in order to avoid impeachment over his involvement in the Watergate scandal. Pursuant to the first section of the 25th Amendment, Ford then became the president, making him the only person ever to hold that office without having been elected as either president or vice presidents. Ford then nominated New York Governor Nelson Rockefeller, a progressive Republican who lent his name to the so-called Rockefeller Republicans of the Eastern Establishment, to serve as his own vice president, and Rockefeller was confirmed by Congress and sworn in on December 19th of 1974. Section 3 of which reads in full, "Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President." This enables the president to voluntarily transfer their powers and duties to their vice president without the vice president becoming president, in accordance with the original intent of Section 1 of Article 2 of the Constitution. The section was invoked in July of 1985 by Ronald Reagan when he underwent colectomy surgery, during which time his vice president, George Herbert Walker Bush, served as the first official acting president of the United States from 11:28 a.m. until 7:22 p.m. on July 13th of 1985. The section has been invoked 3 other times since then, all 3 of them while the president underwent a colonoscopy. On the mornings of June 29th of 2002 and July 21st of 2007, when George Walker Bush assigned his vice president Richard Cheney to serve as acting president, and on the morning of November 19th of 2021, when Joseph Robinette Biden assigned his vice president Kamala Harris to serve as acting president, at which point she officially became the first woman ever to discharge the powers and duties of the President of the United States. Section 4 of which reads in full, "Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. This provision of the amendment has never been officially invoked, though it has been considered on a couple of occasions. Once on March 30th of 1981, when Ronald Reagan was in an intensive care unit under general anesthesia after an attempted assassination, and once on January 6th of 2021, while Donald Trump was actively inciting an attempted insurrection at the Capitol building in Washington, D.C., in order to disrupt the certification of electoral votes after having lost the presidential election 2 months prior. On July 1st of 1971, the state of North Carolina, or perhaps Ohio, or maybe Alabama, depending on who you ask, joined 37 other states by voting to ratify the 26th Amendment to the United States Constitution, which reads in full, "The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. The Congress shall have power to enforce this article by appropriate legislation." The amendment was approved by a Senate vote of 94-0 and a House vote of 401-191 and was ultimately ratified by a total of 43 states, most recently South Dakota in 2014, while the remaining 7 states took no action. The Constitution did not initially establish an age requirement for voting, leaving that decision to the states, most of which set their minimum age at 21, which was in turn the age that Congress initially established in the Selective Training and Service Act of 1940 as the age at which men were eligible to be involuntarily drafted into military service. That act was amended in November of 1942 to lower the age of eligibility to 18 during the Second World War, provoking a movement to similarly lower the voting age, with proponents adopting the slogan, "Old enough to fight, old enough to vote." First Lady Eleanor Roosevelt supported the effort, and Dwight Eisenhower publicly promoted the measure in his 1954 State of the Union address. In 1970, Congress amended the Voting Rights Act of 1965 to lower the voting age to 18 in all elections, and the Supreme Court ruled that year in Oregon v. Mitchell that while the federal government could not dictate the voting ages in state and local elections, Congress did have the authority to set the age for federal elections. On May 5th of 1992, the states of Missouri and Alabama joined 36 other states by voting to ratify the 27th Amendment to the United States Constitution, which reads in full, "No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened, thus preventing members of Congress from authorizing pay increases for themselves to be paid from the United States Treasury during their own terms." The proposal was presented by James Madison almost 203 years earlier as the second of his 12 proposed articles of amendment to the Constitution, 10 of which had been ratified as the Bill of Rights. What would become the 27th Amendment was originally approved by the House of Representatives on August 24th of 1789 and by the Senate on September 9th of that year, after which it was ratified by 7 states over the next 3 years, failing to meet the 3/4 requirements to go into effect. It was later ratified by Ohio in 1873, at which time there were 37 states, and then by Wyoming in 1978, at which time there were 50 states, and then by an additional 29 states during the 10 years from 1983 to 1992, after which it went into effect during the final year of President George Herbert Walker Bush's term. In 1994, the Court of Appeals for the District of Columbia Circuit ruled in Boehner v. Anderson that the amendment would have no effect on congressional cost of living adjustments as established by the Executive Salary Cost of Living Adjustment Act of 1975 and modified in the Ethics Reform Act of 1989.